पढ़ के तैयार होकर आए
जूनियर लोग को पढ़ने नहीं देते आप फाइल, ऐसा जूनियर
हम
आपको
पढ़ना-
बोल के गया।
अब हम नहीं बोलेंगे, बुजुर्ग भी अब स्कूल में जाते हैं तो पढ़ने के लिए, स्कूल जाएंगे तब ना पढ़ेंगे। अब यहाँ बैठ के सब कोई पढ़ना चाहेंगे तो क्या सीखेंगे? हम लोग भी हुजूर उसी रास्ते से गुजरे हैं, ऐसा नहीं कि पहली बार हम लोग यहाँ पहुँचे।
आपके चेंबर से तो जूनियर का छुट्टी 12
सुबह
बजे के पहले होता नहीं है।
रात में
को
जाए पढ़े तब ना।
रात को 12 बजे के पहले आप जूनियर को छुट्टी देते हैं?
जूनियर आते ही नहीं है, छुट्टी क्या देंगे? हम नहीं कंप्लेन करेंगे, सॉरी। This is a peculiar appeal, but I will just point out very limited period. Suit we are the defendant, appellant, concurrent finding. Suit was filed by the plaintiff, respondent, for declaration of right title interest of her Schedule B property and for recovery of possession. Now the learned trial court, if Lordship may kindly see, decreed the suit half. Page para 12, para 12 directly come to para 12. फिर हुजूर नीचे पेज नंबर दिया हुआ है, इनर पेज, रनिंग पेज 52. It may tell you last but 3 pages of the brief. Last but 3 pages.
हाँ ठीक।
पेज 52 नीचे में हुजूर पेज उनका है 14.
हाँ।
तो लॉर्डशिप जस्ट सी पैरा 12, इशू नंबर 8. As far as this issue is concerned, having regard to the facts and circumstances and also having regard to the evidence available on record, I find that it is not just and proper to grant any relief or reliefs to the plaintiffs. Hence, this issue is hereby decided accordingly. This is one part. Next, वो जो 2 लाइन के बाद order में पढ़ा. The suit is be and the same is hereby decreed on condition directly, but in the facts and circumstances without cost. The defendants is directed to hand over the vacant possession of the Schedule B to the plaintiffs within such and such date. Now, your lordship may kindly come to Urdu medium में पढ़ो. Para 4 पढ़ा. Para 4 page 46. Inner page 7. Page 7. Issues. Whether the suit is frame maintainable, whether plaintiff got any valid cause of action, whether the suit is barred by limitation, whether the barred by सब छोड़. 5, 6, 7, 8 in main. Whether the suit is bad for misgender and non-gender of parties. ये important. Paras issue number 6. Whether the plaintiffs are entitled for declaration of their right, title and interest over the Schedule B land and for recovery of possession. Main issue here. 7. Whether the plaintiffs have been in possession of the suit property within 12 years prior to the filing of the suit, whether the plaintiffs are entitled to any relief. Now, Your Honor, your Lordship may kindly see note issue number 6 and 7. Issue number 6 and 7 has been decided, discussion at para 7 of the trial court judge. Para 7. Your Lordship may kindly see there is no reference of any oral evidence except only 2 documents and ultimate finding. Lord, your Lordship may kindly see डॉक्यूमेंट्स छोड़कर कोई डिस्कशन नहीं. अल्टीमेटली द फाइंडिंग, द लॉर्डशिप में काइंडली सी, इफ आई एम नॉट रॉन्ग, इट स्टार्ट्स फ्रॉम पैरा 7, नॉट स्टार्ट्स फ्रॉम पेज 48 and ends at page 51. In this case, on hand, the defendant has neither pleaded nor has brought on record all facts necessary as enumerated herein above to establish his adverse position over the suit B. This is against the defendant, not in favor of the plaintiff. Where is the finding with regard to right, title, interest? If the issue is para 6, issue number 6 and 7, where is the finding of the learned trial court about the right, title, interest of the plaintiffs? Now, it is a settled principle of law. Weakness of the defendants cannot be a ground to decree this. Here it is a suit where decided no relief can be granted. Then your Lordship may kindly see issue number 5. para 10, page 52, inner page 13. This is with regard to misgender. Inner page 13, para 10, issue number 5. As far as this issue is concerned, the plea of the defendant is that he is the director of Messrs. Tridev Construction Private Limited, a company duly registered under the Indian Companies Act, having its office at such and such. Messrs. Tridev Construction Private Limited is a juristic person and who can sue and be sued in the name, and in that view of the matter, he being the director has unnecessarily been dragged in this litigation instead of the firm, which is a necessary party. They have not implemented the firm as a party, the company, registered company. And it may be an issue of misgender of parties. Finding is that. And the law is well settled that the suit cannot be dismissed for misgender of party. If I put a question to myself, in absence of necessary party, how the suit can proceed?
Is there any finding that the property is in possession of Tridev Construction Private?
Yes. The finding is the purchase by. That is the unfortunate part on the part of the learned trial court. Nothing has been recorded with regard to title or right title interest. That is the reason I came to the conclusion. Your Lordship, now I am permitted to. The two things are admitted by the learned trial court. Finding has been recorded that number one, it is a misgender. Number two, that the plaintiffs are not entitled to any relief, and no finding with regard to right title interest. Issue number 6 and 7 have been decided, dealt not in para 7 onwards. For this purpose, I will be permitted to point out, Your Lordship, just see, para 7. Since these issues are most important issues, interrelated as well, therefore the same are being taken up first.
What is the description of the suit property?
Yes, schedule B not in the plaintiff.
Where is
Lordship, just see, for that purpose, case of the plaintiff. And if your Lordship wants to have a copy of the plaintiff, I
No,
can
not
provide.
You just tell us what is the detail of the
Yes,
schedule.
yes. Your Lordship will get in the trial court judgment at paragraph 2, paragraph 2, page 41, inner page 2. May I replace that? The case of the plaintiffs in brief is that the land under Khata number 37, including lands mentioned in Schedule A, originally belonged to Dharu Mahato. In the last cadastral survey record of right, Dharu Mahato had a son who predeceases Dharu Mahato, leaving behind a son namely Mangru Mahato. Mangru Mahato was possessing all the land of Khata number 37 of Moja Hirapur, and therefore his name was created in the cadastral survey record of right in respect of the land under Khata number 37. Mangru Mahato was in peaceful possession over the land. Prior to the preparation of record of right, he continued to possess these land even after publication of record of right in the cadastral survey. Mangru Mahato, while in possession over all these lands in Khata number 37, died leaving behind three sons, namely Asu Mahato, Raghunath Mahato and Shankar Mahato, who inherited all the lands of Mangru Mahato and continued to possess the same peacefully. Mangru Mahato during the lifetime sold and transferred along with other persons portion of the land of plot number 1005, your Lordship may kindly note it, 1005 and 1006, measuring an area of 6 kathas 1.5 chata to Sudhir Chandra Das and Adhir Chandra Das of Hirapur on 24/6/1950. They are my vendors. Now I will just read it. And put them in possession over the same. Thereafter, sons of Mangru Mahato remained in possession of the lands over Khata number 37, Moja Hirapur. Asu Mahato died leaving behind his four sons, who are plaintiffs number 1 to 4, who inherited the interest of Asu Mahato in the lands mentioned in Schedule A. Raghunath Mahato died leaving behind his four sons, who are the plaintiffs number 5 to 8, who inherited the interest of their father and came in joint possession over the same, and other co-sharers. Srikant Mahato, Shankar Mahato died leaving behind his three sons, who are plaintiffs number 9 to 11, So the plaintiffs are the grandsons of the Mangruma, who already sold a part 6 kathas and something in 1958. It is the case of the plaintiff.
You see, the case of the plaintiff is that some portion of the property was sold. It is not in dispute, but while constructing, you have encroached upon certain portion of the land. Amin was appointed,
Who
the
says
measurement was done. So your sale deed is not under dispute. What is under dispute is your possession
Now-
arising out of the sale.
Therefore, my lord, the suit was filed for declaration of right title interest over Schedule B and then for recovery of possession.
Schedule B is not a part of
Yes,
this
yes,
sale
part
deed.
of Schedule A.
Schedule B is not a part of this sale deed. The property
Yes, yes,
involved in the
that
sale
I will
deed.
explain, but
Schedule
that
B
is their case.
is outside this portion.
That is their case. That is to be proved. That is to be proved. And they failed to prove, and the learned trial court also failed to record a finding to that effect. Even right title interest of the plaintiff, what I have read from the.
You read your written statement, para
Yes,
number 3.
I am just coming. Before that, what they have admitted, then you will see para 3. Besides the preliminary objections, the suit is not legally maintainable. Plaintiffs have never in possession in Schedule B within 12 years prior to the filing of the suit. The suit is barred under the provision of the Specific Relief Act. The suit is barred by the principle of estoppel. The defendant has stated that he is the director of Messrs. Trido Construction Private Limited, a company duly registered under the Indian Companies Act, having its office such and such. Dhanbad. Messrs. Trido Construction Private Limited is a juristic person who can sue and be sued in its name. And in that view of the matter, one of the directors has unnecessarily been dragged in this litigation instead of the firm which is necessary party, Messrs. Trido Construction. The Lordship is very well aware that the company is the purchaser. A company is not a party. Company is not a party. That is an admitted position. And this plea was taken specifically by the defendant in their written statement. Under Order 29, my lord, of the CPC, read with Section 251 of the Companies Act.
You claim that you have purchased the property measuring 7 kathas.
This is with regard to 6 katha, then 7 katha, two purchases. I will just come to that. Your Lordship may kindly see another purchase at Trido Construction Company to say 11.55 decimal, that is 6 katha.
The 7 kattha, measuring 7
Measuring-
kattha or say 11.55
Yes, purchase the
decimal in
land
plot number
measuring 7
1002,
kathas or-
1005 and 1006.
Yes, this is by another sale deed.
Which is that sale deed?
That is sale deed is 26/11/2007. This is the sale deed is 26/11/2007
From Deepak Kumar Das.
Deepak, who is son of the Adhir Kumar Das, who is the vendor, a purchaser from the ancestor of the plaintiffs. For rupees 12 lakhs stamp duty on 16.
Deepak Kumar purchased from whom?
The father of Deepak Kumar, that is Sudhir Das and Adhir Das,
Huh.
they have purchased, they have admitted in their plaint also in 1958. So 1958 purchased by the father
You
of.
see, 1958, the description of property is plot number 1005 and 1006, measuring 6 kathas and 1.5 chatak,
Yes,
right?
Yes.
And the description of property in your written statement is not tallying with this.
this is 1002, 1005.
Yes, 1002 is not there in the
There is a
58
second
cell
deed in
deed.
favor of Adhir. 1005.
ऐसा तो नहीं ना दिख रहा आपका written
तो
statement.
1002 पर कोई encroachment का केस
We
नहीं
do
है.
not
So
know.
from the
So that's there is only one cell deed or there are two cell deed?
two cell deeds.
कौन कौन सा name number बताइए date बताइए.
The Lordship may kindly see in the plaint itself, there is a Schedule A property, out of it the Schedule B. So Schedule B and Schedule A, in order to appreciate what is the plot number in Schedule B, so that your Lordship may appreciate the case of the party. Now, your Lordship, I am just completing the defense. The director, 11.55, 1002, 1005 and 1006 under Khata number 80 and 37 of Mujahid Report, standing with a construction, standing thereon within a specific boundary by virtue of registered sale deed such and such from Deepak Kumar Das for valuable construction such and such. An old building get the name of purchaser located in government Sirista and has been exercising diverse act of ownership and possession by paying rent to the state of For development of the aforesaid property, the defendant demolished the old building, leaving the old boundary wall there at the spot, and after sanction of plan from the office of MADA, has constructed an apartment named the Hariom Tower. It is further stated that S.C. Das and brothers, a farm of Hirapur, PS district such and such, had purchased 3 kathas of land of plot number 1002 under Khata number 80 of Moja Hirapur, Moja 7 from Achhe Lal Singh and his wife by virtue of registered sale deed dated 1/6/1953 and came in possession thereof. The vendor Achhe Lal Singh and his wife had taken settlement of 4 kathas in the aforesaid plot number 1002 by virtue of indenture deed number 9411 in the year 1950 in Tekari settlement, and the land had constructed the house and boundary wall thereon. S.C. Das and his brother had also purchased 6 kathas. This is the deed note which I have already referred. 1005 and 1006 from Balram Mahato, Sivilal Mahato, Bholu Mahato and Dalu Mahato, all sons of Rasik Mahato, Srimati Sundari Mahatani and such and such, such and such. By virtue of registered sale deed dated 24/6/1958, came in possession thereof. While constructing the building over their purchased land, the said S.C. Das and brothers might have made construction also over the same portion of plot number 1003, and they remained in possession thereof without any let and hindrance from any corner since the 1958. And after their demise, their heirs continued to occupation of the said building without any interruption till 25/11/2007, and on 26/11/2007, the said old building and land was transferred to Messrs. Tridev Construction Private Limited, as stated above. Thus, the vendors of the defendants were in exclusive possession of their buildings situated over plot number 1002, 1006, 1005, and some portion of 1003 without any interruption from any corner. After purchase, the defendant stepped into the shoes of the vendors. On getting the plan sanctioned by MADA, the defendants constructed an apartment named Hariom Tower, and virtually the construction work of the apartment is complete and its furnishing work is going on. But the aforesaid apartment was not constructed by the defendant within a day or two, and the plaintiffs all of a sudden came with a plea that the defendant had encroached upon the land of the plaintiffs, which has been made suit property described in Schedule B of the plan. As a matter of fact, whatsoever construction has been made by the defendant, it has been made over the land where the old building of S.C. Das and brothers was existing, and the defendant has not encroached any land more than what was in possession of the vendor. The area is thickly populated and was no vacant land which the defendant can be said to have been encroached. There are houses, and on these 3 sides of the north, east and west, and on the southern side there exists a road. If any encroachment was done, it was done by the vendors of the defendant long back, and not by the defendant. The plaintiffs have developed a habit of laying claim where old buildings were demolished for construction for new one, with the allegation that the encroachment is there with a sole motive to squeeze money from the person concerned at the present market rate. Keeping that in view, the present suit has been filed, without having any cause of action. The plaintiffs have not mentioned the names or all the vendors of the sale deed number such and such 24/6/1958. They are guilty of suppression of material facts. No measurement by the so-called Anchana mill was ever made in presence of the defendant. A duplicate report has been prepared to suit their purpose. No notice of any proceeding under section 107 or 144 CRPC ever. Now, I have read below the issues. Now, your Lordship may kindly come to paragraph 7 onwards, the findings. The documents which have been filed below, that is paragraph 5 and 6.
You see, the schedule of the Schedule B was regarding the encroachment in plot number 1003.
Yes.
Right?
Yes.
And,
But that
and some portion of 1005. So 1003, you do not claim any title over
Yes,
1003.
I have said that I have purchased it from.
You have purchased it, but your vendor never had title over 1003.
That is in 1958.
Whatever be the date. But
that is to be.
it is not your
that
case.
is- Your Lordship
It
may
is
kindly
not your
appreciate.
case that
First of all, my lord, when a suit was filed for declaration of their right title interest,
yes,
where is the declaration of right title interest? Unless the plaintiff title is declared, how the court can presume that I have encroached or not? Now, whether the weakness of the defendant can be relied upon to decree a suit, when there is a specific finding of the trial court, then no relief can be granted. If I am not wrong, I have read below the entire paragraph.
there is no dispute with regard
There
to
is a
title of 1003 because you
There
do
is
not.
dispute. I have stated
No.
that we have purchased from the land.
No,
we
you
have
might
purchased.
have purchased, but the land originally belonged to the plaintiff 1003 also. That is not in dispute.
That is a dispute in 1953. Achelal Singh, who
Achelal
purchased
Singh,
it by
no.
indenture dated 1953.
Purchase which property?
Your Lordship, just see, I have read just now.
Which property
by
did he
276
purchase?
kathas and 3 kathas.
From whom? Who was the vendor?
It is settled. It is settled. Therefore, that deed was to be challenged in 1953. If it was wrongly done so,
Not necessary.
Your Lordship, just see, my lord, from the written statement, we have stated, my lord, in paragraph. Your Lordship, just see, my lord, just page number 5, inner page 5, running page 44.
1002 only, not 1003.
Your Lordship, may kindly see he had purchased 3 kathas of land in plot number 1002, khata number 18.
Yes.
And this third case is that defendant has purchased the land which is in occupation of their vendor
No.
since 1958. With a building.
1003 was never
But that must be a
purchased.
finding, my lord. Your Lordship, may kindly see where is the
There is
finding?
a finding. You see,
Just-
from the perusal of Exhibit 1/8, it is
Yes,
crystal
I'm
clear
just
that the
coming to
land
that,
of plot number 1003
Without
was
discussion of
admittedly
the
not
limit-
sold and transferred.
Without discussion of any PWs
You
or
see,
DWs.
not-
No
you see,
discussion.
The
Your
point
Lordship, just
is,
see,
the point is, it was never your case that plot number 1003 was
it
purchased.
was my case that what I have in occupation, that is in occupation of my vendor, and I have stepped into the shoes of my
Very-
vendor.
very
That is my case.
Without any description of property.
I have,
The plot number and
because
a
it is for the plaintiff to describe.
you see,
It is the case, onus lies upon the plaintiff to establish the encroachment.
okay.
And first of all, they have to establish their right title interest. Then it shifts to the defendant. Here it is a case where the learned trial court failed to observe that it is the onus on the plaintiff to prove, first of all. And if the plaintiff proved it and title is found, possession is found with the plaintiff, then it shifts to the defendant. It cannot be reversal side. Because I am not the suit, did not file the suit. The suit was filed by the plaintiff. Now, when the learned court below, learned trial court has recorded in its specifical and categorical words that the plaintiffs are not entitled to any relief. Relief means the relief of declaration of right title interest as well as recovery of possession. It is when no cross objection was filed by the plaintiff. It is a finding of fact recorded by the learned trial court. If it was erroneous, it is against the plaintiff. And misgender, that has also been admitted. So under order 29 of the CPC, a company can sue and company can be sued. Now in absence of a proper party, the vendor is vendee is the company, not this appellant before your lordship. Vendee is the company and the company is not a party. Admitted. And it has been held by the learned trial court. Yes, it is a misgender of party. If it is a misgender of party, then how this suit could have been decreed? This is a question may I put to myself. So in absence of a proper party, the company, in absence of a right title interest declaration, and in absence of a discussion of any of the PWs or any of the DWs, it is an original court of finding of fact. Then your lordship will not find subject to verification. If I am not wrong, there is no reference of any of the oral evidence. Only on presumption and by referring a judgment, the learned court below came to what has been recorded, your lordship, just see, page number 12. In the case on hand, the defendant has neither pleaded nor brought on record. We have pleaded. I have just now read what is my pleading. all facts necessary to enumerate it, to establish adverse possession over the Schedule B land. It is my pleading that I have acquired this possession from my vendor, and my vendor acquired it and constructed a house, and what was in his possession, we purchased it. We stepped into the shoes of the vendor. So my humble submission for Lordship would be that misgender is one of the fatal ground to dismiss the suit. Another finding which has been recorded by the learned trial court, Your Lordship, just see, issues have been framed with regard to right title interest. But what is the answer? No answer is on the judgment. Issues were framed whether the plaintiffs have got right title interest over the suit property. This is the issue number 6 and 7. But where is the finding that yes, plaintiffs have the right title interest over the suit property? There is no whisper about it, if I am not wrong. The trial court judgment does not speak a single word that there was the issue number 6 and 7 were decided in favor of the plaintiffs.
What about the appellate court?
Now I am coming to it. Now Your Lordship may kindly appreciate. We preferred appeal on account of the direction given in the order, the last part of the trial court judgment, directing the defendant to hand over possession. So we preferred appeal. No, admittedly, no cross appeal has been preferred.
That's right.
By the plaintiff. Now Your Lordship may kindly come to appellate court judgment. That the questions formulated, Your Lordship will kindly see paragraph 4. Issues have been quoted in the terms as have been quoted by the learned trial. Now, reference of DWs and PWs is there in para 6 and 5 and 6. Then the submission have been recorded in para 7. Para 9, Your Lordship may kindly see.
You read para 7 also.
Para 7.
Para 7.
Yes. Heard both sides. The learned counsel of the appellant defendant states, as per the evidence on record, the learned lower court should have dismissed the suit. The documentary evidence were not properly evaluated. The defendant appellant is bona fide purchaser. Issue number 6 and 7 were wrongly decided. The oral and written submission of the appellant defendant were not considered. The learned lower court has not discussed the evidence of the plaintiffs, whereas which were sufficient to hold that the plaintiffs and respondents are not in possession over the suit property for more than a statutory period of 12 years. The learned lower court has failed to appreciate the principle of taking of possession. Taking hoga, TSC क्या है? Taking of possession. The evidence on record goes to show that Tridev Construction Private Limited has purchased the land with an old building constructed in the year 1958 by previous owners, which also includes Schedule B property, and they remained in possession till they sold the house and land to Messrs. Tridev Construction, of which the defendant is a director. As per settled principle of law, the defendant was in possession of the property and a person claimed his title over the same. Then he has to show that he or anyone through whom he claims possession was in possession for more than a statutory period. In this case, the defendant has claimed his possession from his vendor, that is previous owner of the land and houses, which includes the suit property. The learned lower court failed to appreciate that if the rightful owner does not come forward and assert his title by process of law within the statutory period of limitation, then his right extinguished and the possessory owner acquired absolute right. The defendant appellant have purchased the old dilapidated building from S.C. Das and others, and after demolishing of old construction, they had constructed Horiom Towers within boundary wall, which still exists at this spot. The learned lower court has erred in placing reliance on measurement report of the map, Exhibit 3, without examination of the concerned Amin. That is an inadmissible in law. This is private Amin who prepared a map and they have produced it. But it is not any statutory document, nor it was proved by the author. Author was not before the court. It was inadmissible. The plaintiffs have filed petition dated 9/8/2011 for appointment of surveying pleader commissioner and rejoinder was filed by the defendant appellant on 18/9/2011. The order was passed by the learned lower court that the plaintiffs may move the petition of appointment of surveying pleader commissioner at later stage, but the plaintiff never traced that petition, and in absence of surveying pleader commissioner, his report exhibit 3 was marked without examination of concerned Amin. So issue number 6 and 7 was wrongly decided. The petition dated 9/8/11 was not disposed of. The learned counsel of the plaintiff had discussed in detail the oral and documentary evidence cites AIR 2019 Supreme Court such and such, and asked that the judgment and decree passed by the learned lower court should be set aside. Per contra, the argument advanced at bar on behalf of the plaintiff respondent is that the learned lower court has committed an error, no error in deciding the issue. So there is no error in para 10 declaring that they are not entitled to any relief. There is no error. While deciding issue number 6 and 7, the learned lower court has rightly held the defendant has neither pleaded nor has brought on record all the facts necessary as required to establish his adverse position over Schedule B property. There is no evidence on record that the defendant appellant had purchased plot number 1003. The Amin Commissioner report exhibit 3 clearly goes to show that there is encroachment in plot number 103 and 105. 105 is the purchase property. The learned counsel for the respondent plaintiffs have discussed and detailed the oral and documentary evidence on record as well as the provision of law related to adverse position and urged that the judgment and decree passed by the learned trial court is upheld and the appeal should be dismissed. After going through the pleadings, the oral and documentary evidences on record, the judgment and decree passed by the learned lower court and the grounds taken in memo of appeal, and after hearing both the parties, issues points number 1. Are the plaintiffs respondents entitled for declaration of right title interest over the suit property and entitled for recovery of possession? Issue number 1. Point number 2. Is the suit hit by provision of adverse possession? So in my humble submission, the issue with regard to non-gender or misgender of party could not be taken into consideration, nor it has been framed or even. On the other day, I have submitted a judgment of the Supreme Court. Each and every point has to be re-appreciated by the appellate court. It is the duty cast upon it. The judgment AIR 2022 Supreme Court, on that day I cited.
Do you have a copy of the plaint?
Plaintiff. प्लेंट रिटर्न दोनों हैं. Schedule B is within Schedule A.
The Schedule Schedule B is only in connection with plot number 1003.
1003.
There is no such
No other plot.
no other plot is involved.
Yes.
Right?
Yes.
And 1003 is not a part of your.
But now, if I put a
Sentencing.
question to myself, I have not before the court as
That's
a plaintiff. It is the plaintiff who has to prove it. And when there is a specific issue has been framed with regard to right title interest of plaintiff, there is issue, particular issue has been framed. Where is the reply to that issue? And the learned appellate court committed an error in the verdict of the Honorable Supreme Court that Order 21, Rule 31, Order 41, Rule 31, he has to address the judgment by quoting each and every issue and to reply it. This is the Honorable Supreme Court held. So only 2 issues have been picked up out of these 8 issues. No issue with regard to when it is a specific case of the defendant that the company is the purchaser and company acquired the property and company is not a party. Suit fails in absence of proper party. And it is an admitted position. Perversity in the impugn appellate
This
judge.
property in the month of September 2008 was purchased by whom? The company. 2008 deed.
रजिस्टर्ड
2008
डीड का तो रेफरेंस है 2007 हमरा रिटन स्टेटमेंट में भी लिखे हैं और ऐसे जजमेंट में भी रेफरेंस है एग्जिबिट है दैट इज एन एग्जिबिट ट्रायल कोर्ट में स्पेसिफिकली एग्जिबिट्स का डिस्क्रिप्शन वेयर टू यू लॉर्डशिप वुड फाइंड Exhibit 1 by A, they have filed our purchase deed 10613 dated 26/11/2007 along with map. They have also exhibited the 1958 deed sale deed by my vendors, that is Exhibit 2, and we have also produced 1953 deed, registered deed.
आपका
Exhibit
जो
A.
1953 वगैरह कोई 1003 से रिलेटेड नहीं है ना? Which deed is related to 1003?
Now, Your Lordship may kindly see the case of the defendant in reply to the case of the plaintiff that we have occupied the portion of the land which we have was in occupation of my vendor since 1958 and 1953 onwards, along with a dilapidated house. And after getting a sanction map from MADA, after getting right title interest over the property, adjacent property, if I confine myself, that we have purchased 1002, 1005, 1006. With regard to 1003, there was a construction which was occupied by my vendor in 1958.
From where is the finding that the construction?
That is my submission. There is no finding. Therefore, how the suit could have been affirmed? Right. The title suit declaring that the plaintiffs are not entitled to any relief, that has been confirmed, and still the appeal was dismissed and suit was decreed. That is my submission. I am not adding a single word to the finding which has been recorded by the learned trial court in para 10. Para 10 it should have been that plaintiffs are entitled to each and every relief. I would have shut my mouth. Misgender, it is they admit that yes, company is a necessary party and he has not been implicated, but the suit cannot be dismissed. Very fun.
Issue number 6 was framed whether the plaintiffs are entitled for declaration of right title and
Yes,
interest,
yes, yes.
but there is no such declaration.
No finding. No finding by both the courts. Subject to verification. No finding.
With respect to Schedule B property.
Unless they claim what they have claimed, that should be proved first. Then the question of encroachment comes, and then my explanation has to be offered. So the onus always lies with the plaintiff who brought the suit before the court. And if they discharge their onus, then it shifts to us. This is the basic law.
Vicky heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that although a specific issue was framed by the learned trial court as issue number 6 as to whether the plaintiff was entitled for declaration of the right title and interest over Schedule B land and for recovery of possession, but the learned trial court has not declared the title of the plaintiff over Schedule B land. He has also submitted that Schedule B land Schedule B land is in plot number 1003 and was in possession of the company, namely Messrs. Tridev Construction Private Limited. But in spite of objection raised by the defendant, the said company was not made party, which is certainly a juristic person. He submits that the suit was fit to be dismissed on account of non-joinder of necessary party. A specific issue was framed in this regard with respect to issue number 5, but the learned court, but the learned trial court held that that it could be a case of misjoinder of party and that the suit cannot be dismissed for misjoinder of parties. The learned counsel submits that even the appellate court,
The para 12 of the trial court, इसमें मुझे बोले कि they are not entitled to any relief. Para 12, page
हाँ.
number 14, last but one.
the learned नहीं ये तो issue number 8
अच्छा,
है.
ठीक, ठीक.
The learned counsel has also submitted that the appellate court has also not given any declaration with respect to the title as claimed by the plaintiff.
No point for consideration with regard to party. Misgender, non-gender. Para 9, only 2 points were considered. Page 11.
And the appellate court did not frame any point of consideration with regard to non-joinder of party.
Onus has been wrongly shifted to the defendant.
He has also submitted that the onus has been wrongly shifted to the defendant to prove his adverse possession, although there was no finding regarding the title of the plaintiff. This second appeal is admitted for hearing on the following substantial questions
A,
of
B
law.
and C. Page number 11, memo copy. A, B, F.
On following questions of law A, B and F. इसको put करें. ये पेज नंबर 11 में है. सब्सटैंशियल क्वेश्चन ऑफ लॉ अलग से रहता है, वेदर से शुरू होता है ना. इशू नोटिस टू respondent number.
All the respondents.
क्या है मल्टी
Correspondence
स्टोरी
number
बिल्डिंग
1
है?
to
आपके प्लॉट आपने मल्टी स्टोरी बिल्डिंग बनाया है ना?
1 to 16.
Issue
Plaintiff
notice to respondent number 1 to
16.
16 for which requisite under
Both processes. All are of
ordinary process as well as through speed post.
District of Dhamra.
As well as through speed post be filed by the
Within 2 weeks.
appellant by 20th of January. Office to track speed post delivery. Let the records be called for from the concerned court. Post this case on 24th March, awaiting service report
Alright.
and the records.
And again, offering my sorry because I could not attend in the
कोई
first
बात
call.
नहीं, ये क्या है? ये रिकॉर्ड आ गया है क्या?
नहीं वो हमारा था.
वो आपका है, वापस लीजिए.
I am very sorry, not again I am.
कोई बात नहीं. It's
Before
a second
speaking, I
appeal.
could
These
not
matters
appear
are
in the
going to
first call.
are bound to take time.
I am very sorry.
No problem.
Passover case, item 6, second appeal 104 of 2020.
Heard the learned counsel appearing on behalf of the appellant. This second appeal has been filed against the judgment dated 28/2/2020, passed by learned District Judge 1 Giridih in civil appeal number 18 of 2017, whereby the appeal preferred by the appellants has been dismissed. The title suit was decreed in favor of the plaintiff by judgment dated 4/3/2017 in title suit number 41 of 2008, passed by learned civil judge within bracket senior division bracket close dash Roman 3 Giridih. The learned counsel for the appellant, while referring to the substantial questions of law, has submitted that the learned court has submitted that the question which arises for consideration is, inverted comma, whether the learned court has disbelieved has submitted that whether the learned courts were justified in disbelieving the registered patta of 1919 with bracket exhibit A-3 and rely upon Sada Hukumnama and unregistered documents of the plaintiff while deciding issue number 7, and has thereby issue number 7, that should be sufficient. That is the thing. While deciding issue number 7, the learned counsel for the appellant has submitted that the plaintiff, that the defendants were claiming right, title, interest and possession by virtue of registered deed of the year 2019 followed by subsequent deed, and the plaintiff was claiming the same on the basis of Sada Hukumnama followed by rent receipts issued by the ex-landlord, and it was followed by entries made in the record of right and subsequent rent receipts issued in their favor. The learned counsel submits that the sale deed of the year 1919 has been disbelieved, and consequently all the subsequent sale deeds arising therefrom have been disbelieved. He submits that once there is a registered sale deed in connection with the property, there was no question of any reliance on Sada Hukumnama and the rent receipts issued by the landlord, and therefore, on view of these facts, in spite of concurrent findings recorded by both the courts, the present appeal is fit to be admitted on the aforesaid substantial question of law. After hearing the learned counsel appearing on behalf of the appellant, this court finds that it was the case of the plaintiff that Gosai Kharagdari Gir was the tenure holder in connection with property be under Thana number 312 in district of Giridih, and consisting of 10.56 acres of altogether 16 plots of Khata number 1, which was recorded as Bakast land of the said person in last cadastral survey operation. It was therefore the case that the land was said Kharagdari Gir settled the land, aforesaid land, along with trees in favor of one Rituram on receipt of Nazrana and fixed the rent, and he came in possession of the property, and after settlement he started paying rent to the landlord, who also issued rent receipt. And he has been cultivating the said land. Upon vesting of Zamindari, the name of Rituram was also entered in register 2. And the plaintiff and Rituram also possessed ancestral land of area 4.36 acres in Khata number 31, and demand in register 2 with respect of 4.36 ancestral land was also opened in his name. It is further case that Rituram started paying rent jointly for the rent Khata number 1 and Khata number 31. And he never surrendered his settled land of area 10.56 acres at any point of time. It was his further case that one deed number 673 dated 24/9/2019, which relating to 2.86 acres of land, was forged, manufactured, illegal and inoperative, and it was only a paper transaction. And that one Jagdish Ram got the forged sale deed executed in favor of his mother, namely Umia, through a fictitious lady, namely Mosama Balia Khatun, wife of Jhari Khar, in favor of Masumat Umia. The sale deed was numbered as 9128 dated 8/10/1953. And on the basis of this sale deed, Jagdish Ram got the name of Mosamat Umia Devi entered in register too. But when this fact came to the knowledge of plaintiff's father, the appropriate petition was filed for cancellation of the demand, which was duly cancelled by cancellation case number 17 of 1991. However, Mosamat Umia Khadia sold a portion of the gifted a portion of the property by gift deed number 4252 dated 6/6/1990 in favor of his daughter, namely Fudo Devi, and Fudo Devi sold the property to Prasadi Ram Defend number 1 by executing a registered sale deed number 2996 dated 16/5/2008. And on the basis of the same, Prasadi Rana started claiming right title and interest on the property. And when he went to the property to take possession, the same was opposed by the plaintiff, and the cause of action arose on 18/5/2008 when the defendant number 1 went upon the land on plot number 341, denying the title of the plaintiff, and ultimately the suit was filed. The defendant number 1 and 2 appeared and contested the suit by stating that the plaintiff was claiming the property through settlement, but no such settlement was made in favor of Rituram, and if any hukumnama and rent receipts were issued, the same be presumed as manufactured and forged hukumnama. The defendant also denied that Rituram ever came in possession of 10.56 acres of land, and also denied that name of Rituram was ever entered in register 2 in respect of the said land. The defendant also denied that the claim of plaintiff that Mausamat Balia Kaharain was a fictitious lady was incorrect, and that in the year 1919, the then landlord Gosai Kharagdari Gir had settled 2.86 acres of land 2.86 acres of land under plot number 243, 268, 278, 316, 312, 365, 405 at village Nimdi to Balia Kaharin, wife of late Jhari Kahar, by virtue of registered patta number 673 dated 24/4/2019, and put the settlee in khas possession of the said property. And it was also claimed that Mausamat Balia Kaharin had sold 1.10 acres out of 2.86 acres to Mausamat Umia by virtue of registered sale deed dated 8/10/1953. Thereafter, Mausamat Umia came in khas possession of the property, and after her death, her only son Jagdish Ram transferred 1/8 decimal of land out of 1.10 acres to her daughter Fudo Devi by virtue of registered gift deed dated 6/6/1990, and thereafter the Doni Fudo Devi came in possession of the property and sold the gifted property to defendant number 1 Prasadi Rana by virtue of registered sale deed dated 16/5/2008, and consequently the defendant number 1 came in possession of the property and denied the right, title, interest and possession of the plaintiff, and asserted that the suit was not maintainable and was meant to be dismissed. On the basis of the plaint and written statement, the following issues were framed by the learned trial court. Para 6. The learned trial court considered the issue number 7, which was the most important issue, as to whether the plaintiff and pro forma defendant number 3 to 6 have valid right, title and interest on the suit land. And while deciding issue number 7, the learned trial court recorded a finding that the perusal of pleadings of the plaintiff and respondent transpired that the plaintiff was claiming the property in khata number 1 and also khata number 31, and after vesting of zamindari in the state of Bihar, the said Rituram was paying rent of Khata number 31 with Khata number 1, and 2 rent receipts were also exhibited, which were issued by the then landlord as Exhibit 1G and 1H, and the certified copy of that Khatiyan was also exhibited as Exhibit 3. Sada Hukumnama was exhibited as Exhibit 5, and it was proved that Rituram and his successor and on the other hand, after considering the materials held that the registered patta in favor of Balia Kharain was a paper transaction without delivery of possession, and settlement in favor of Rituram, although unregistered, was followed by delivery of possession and rent receipts, and also supported by the certified copy of the registered 2, which showed that the land was settled in favor of Rituram by the then landlord and was supported by rent receipt. The findings in connection with issue number 7 as given by the learned trial court is quoted as under. ये internal page 13 of trial court judgment quote करेंगे. So far as the learned appellate court is concerned, the learned appellate court also scrutinized the materials on record and recorded a finding that the ये ट्रायल कोर्ट का ना यहाँ से लेंगे, ठीक है, वो ना एपेलेट कोर्ट से निकालेंगे, कॉन्करेंट फाइंडिंग है ट्रायल कोर्ट का पेज नंबर 36 से लेंगे और वो वाला फाइंडिंग है एपेलेट कोर्ट का, ठीक है. The learned appellate court also considered the materials on record and held that Rituram was recognized as tenant with respect to 10.56 acres of land by the then landlord, and after vesting, an appropriate entry was made in connection with his right under Register 2. The learned trial court held that the plaintiff and pro forma defendant number 3 to 6 had got valid right title interest in favor of Rituram by the then landlord. The learned trial court also recorded that the plaintiff had the possession of the property and therefore there was no occasion, and therefore issue number 6 as framed by the learned trial court was also decided against the defendant. This court finds that there are concurrent findings recorded by both the courts by referring to the materials on record with regard to right, title, interest and possession of Rituram which was created by virtue of settlement made by the ex-landlord Gosai Kharagdari Gir, who settled the property in his favor, and after vesting of zamindari, his name was also entered into register deed. In view of the aforesaid facts and circumstances, this court finds that the learned courts have rightly disbelieved the registered. This court finds that both the courts have recorded concurrent findings considering the materials on record, and no question of law, much less substantial question of law, arises before this court for consideration in the second appeal, which is hereby dismissed.
From Delhi for orders item E,
Appearance
first 43 of 2020.
What is it? Why has it come?
1/11/7/2024 notices were issued to the student number 4587.
Okay.
Service report will not be coming for respondent number 5 and 7. Although respondent number 1 to 4 appeared through Wakalam.
1 to 4 has appeared.
1 to 4 have appeared through Wakalam.
5 and 7.
5 and 7. Service report.
Who are respondent number 5 and 7?
5 is the Siri Equipment Finance Private Limited, and 7 is the regional manager ICICI Lombard General Insurance Company.
4 has appeared.
4
4 is also chairman ICICI.
one respondent number 1 to 4 appears to Wakalam.
कहाँ लिखा हुआ है respondent number 1 to 4?
Black boy.
Where is Mr. Alok Lal? कहाँ है? He has not come. तो कौन बच गया? 5 and 7.
5 and 7.
Issue notice upon respondent number 5 through speed post, for which requisites be filed by the appellant एडमिट हो चुका है क्या? विद इन टाइम है. एडमिट करके नोटिस कर देते, क्या ही करना है, एडमिशन के पहले ही नोटिस हुआ है इसमें. नहीं, लिमिटेशन है. यस कैसे बोलते, लिमिटेशन कर लो.
That has been condoned.
आइए पेंडिंग है 92 और 21.
नहीं पेंडिंग नहीं,
ये क्या चीज़ में आया, ऑर्डर्स में?
ऑर्डर्स में
सर्विस रिपोर्ट नहीं आया इसलिए ऑर्डर में.
अच्छा. इशू नोटिस टू वही रेस्पॉन्ड नंबर 5, ठीक है, थ्रू स्पीड पोस्ट, फॉर विच रिक्वेजिट्स बी फाइल्ड बाय मंडे, ऑफिस टू ट्रैक स्पीड पोस्ट डिलीवरी. So far as respondent number 7 is concerned, The respondent number 7 is the regional manager of ICICI Lombard General Insurance Company Limited. And respondent number 4 is the chairman of ICICI Lombard General Insurance Company Limited. Respondent number 4 has appeared by filing wakalatnama. Mr. Alok Lal has entered appearance on behalf of respondent number 4. Mr. Alok Lal is not appearing today in this court. He is directed to seek instructions as to whether he would accept notice on behalf of respondent number 7 as well. Pose this case on undelivered registered cover क्यों आ गया है वापस? Why it has returned undelivered?
Respondent number 4 का लेकर वो appear कर चुका.
अच्छा अच्छा ठीक है. Pose this case on 3rd of March.
Speed code respondent number 5.
Only 5. वो खुद ही ले लेंगे, नोटिस ले लेंगे.
Appearance. Item 10, first appeal 172 of 2023.
हाँ, yes.
This is for service of fresh notice. Upon respondent number 4, 6 to 9, respondent number 11 and 12.
ट्रेस ही नहीं हो पाए तो क्या ही होगा?
गलत.
लिखिए, as per office note, the notice has been received on behalf of respondent number 5 and respondent number 5, 10 and 13. The notice sent through ordinary process has been received by close relative of respondent number 5, 10 and 13. The notice upon respondent number 5, 10 and 13 is accepted as validly served. So far as respondent number 4, 6 to 9, 11 and 12 are concerned, the service report reveals that they could not be traced. Counsel for the appellant prays for time to either take steps for service of notice upon respondent number 4, 6 to 9, 11 and 12 at their present and complete address, or to file appropriate petition.
For 4 weeks time.
Pray for and is granted 4 weeks time. Or to file appropriate petition seeking substituted service of notice.
Written copy may be utilized.
The returned copy नहीं, ये हम आपको परमिशन नहीं दे सकते. 2 पन्ना डालना है, इसमें क्या रिटर्न कॉपी आपको? The requisites we filed by within नहीं by 4 weeks, no?
Yeah.
Alright. Just a moment. Close this case on 11th of March, awaiting service.
Your Ladyship, I am appearing on behalf of the first set of respondent, ECL, Eastern Coalfield Limited.
That where is it?
Deeply.
For admission item 11.
या तो आइए फाइल कर दीजिएगा फॉर सब्स्टिट्यूटेड सर्विस, सुन रहे हैं आप? या तो आइए फाइल कर दीजिएगा फॉर सब्स्टिट्यूटेड सर्विस या फिर प्रेजेंट एंड करेक्ट एड्रेस पर रिक्विजिट फाइल कर.
For admission item 11, first appeal 153 of 2023.
सॉरी,
I'm praying for next time.
क्या चीज़ के लिए? यस,
This case is argued by Mr. Rajiv Indian.
आर्गुमेंट क्या करना है? फर्स्ट अपील एडमिशन में है ना, नॉट येट एडमिटेड.
नहीं एडमिट नहीं क्या आ गया है.
एलसीआर भी आ गया, कॉल पर एलसीआर हुआ. The records have already been received from the concerned court. Let this appeal be admitted for final hearing. For all the respondents,
Yes, only one. Raju Chaudhary.
the sole respondent has already appeared. Who is present in the court. क्या मैटर है?
The plaintiff, the respondent here, filed a suit for eviction and eviction the defendant, evicting the defendant, and also the declaration of title over the suit, which has been declared in favor of the plaintiff.
And you are a defendant.
Yes.
टेनेंसी है क्या? टेनेंसी है कि एक्सपायर्ड क्या है?
Plaintiff says that we are the permissive position of the suit. There is no any documents made by the plaintiff which shows that I am the permissive position of the suit.
आपने टाइटल क्लेम किया है?
I am not like that. मैंने टाइटल नहीं फाइल किया है. टाइटल फाइल बाय plaintiff. I am the defendant in the suit.
टाइटल आपने क्लेम किया है क्या? एडवर्स पोजीशन क्लेम किया है? ठीक है ना? ना टाइटल क्लेम किया है ना एडवर्स पोजीशन क्लेम किया है. प्लेंटिफ का टाइटल है, बात खत्म है. क्या ही फर्क है?
मैंने पूरा रिपोर्ट में देखा है.
Title has been declared in our favor.
That's right.
Any date may be for hearing.
The appellant is the defendant before this court. The plaintiff claimed that the defendant was put under permissive possession and title of the plaintiff has been declared by the impugner. कब करेंगे बताइए?
After 2 weeks.
Post this case for final disposal on February 25th.
Organized children.
Item 12, contempt civil 1086 of 2023.
My Lord, we have moved before the Honorable Supreme Court in SLP number SLP Your Lordship, and there is an order of stay in the criminal proceeding, Your Lordship, on a condition that payment is required to be made, Your Lordship, and in compliance of the order of the Honorable Supreme Court, Your Lordship, admitted dues has already been paid.
लास्ट ऑर्डर इसमें ऑर्डर जो था लॉर्डशिप का नहीं है.
There is a stay of contempt proceeding.
My Lord,
आपने जमा कर दिया?
my Lord,
ठीक. आपने लिखा है कि अमाउंट जमा कर दिया?
my Lord, हमारा कोई एफिडेविट लाया नहीं है, और ये है मेरे पास कॉपी, और इसको
आप
हमने
आफ्टर डिस्पोजल ऑफ दिस केस कर देते हैं?
my Lord,
इसमें बेंच हमको लगता है नोट किया जाएगा वहाँ.
कहाँ?
कोर्ट का ऑर्डर जो है वो जस्टिस के भी ने
कंटेम्प्ट तो मेरा ही ऑर्डर है ना,
कंटेम्प्ट है.
तो कंटेम्प्ट
Original-
सेम बेंच के पास आता है. ऐसा कुछ रोस्टर चेंज होने से कंटेम्प्ट का जुरिस्डिक्शन थोड़ी चेंज हो जाएगा.
जो ओरिजिनल ऑर्डर है वो जिस
ओरिजिनल ऑर्डर किसने पास किया?
वीक में जो ऑर्डर
हाँ, मिस्टर केपी देव का.
वो जैसा वो जो रोस्टर है उसके हिसाब से ये
अच्छा, दूसरे कोर्ट में जाएगा क्या ये?
वैसे तो स्टे हो गया है इसमें तो.
नहीं, हम लोग तो ऐसा कुछ नहीं, दूसरे कोर्ट में जाएगा तो आपको क्या ही करना है इसमें.
order is passed to the Honorable Mr. K.P. Devi.
It has been reported that the on account of change of roster, the present case has to be placed before another bench. The order in the writ court has been passed by Honorable Mr. Justice Kailash Prasad Dev. आपने डिपॉजिट किया है, आपको तो डिसबर्सल का ऑर्डर था,
My Lord,
है ना?
सुप्रीम कोर्ट गया वहाँ से स्टे
my
मिल
Lord,
गया.
ये नहीं, स्टे तो मिला है. ओरिजिनल कॉम्पनसेशन अमाउंट वाज टू बी डिस्पर्स्ड टू द ओनर्स.
my Lord,
आप तो ओनर्स को डिस्पर्स कर
my
दिया.
Lord, this is the charge
ये
that
कोई
has
बात-
been supplied by the department.
कोई बात, वो आप अपना फाइल कर
My
दीजिएगा.
Lord,
ठीक. Post this case before appropriate bench as per roster.
Item 13, contempt civil 393 of 2024.
Yes.
Regent order has been passed.
Order.
Rejected the claim of the petition. Liberty may be given.
Contempt civil 394 of 24. It has been submitted by the learned counsel for the petitioner that recent order has been passed pursuant to order passed in WPS number 4118 of 2018, but the grievance of the petitioner has not been redressed. He submits that liberty be reserved with the petitioner to take steps in accordance. The learned counsel for the opposite party has no serious objection. Okay. Considering the submissions, the present contempt proceedings are hereby dropped. Liberty is reserved with the petitioner to take appropriate steps as may be permissible under law in connection with the reason.
For hearing under order of 41 rule 11, item 14, second appeal 131 of 2019.
pending litigation.
IA
IA
pending
number 3734 of 2023
for
for deletion of the respondent number 1. Name of the
who
respondent.
is respond number 1?
She was the wife of the original defendant litigation. After during the pendency of the suit, the original defendant died. He was substituted by this lady and the two minor children then. Now she has expired during the pendency. Ladyship, exact date we could not ascertain because we are in the litigating terms. It was not informed to us that what is the date. Earlier this
IA disposed of हो चुका है.
no, one IA was disposed of earlier because the original plaintiff also died and her daughter, she has preferred this appeal. And this is the second IA, ladyship. If I am not
IA number
IA number 3734 of 2023.
1424.
4/10/24 को disposal.
Ladyship, on the merits of the case, ladyship. This is a second appeal preferred by the plaintiff here, and there is a concurrent finding by the
Just a
court.
moment. 4/10/20. Let me just. Yes.
There is a concurrent finding by both the courts below. The suit was filed as TS number 110 of 1986, and the suit was filed for the following reliefs: decree for declaring exclusive royalty right over 4.98 acres of the land at Khata number such and such. Second, decree declaring defendant, the original defendant,
Suit
not
of 86.
yes, ladyship. Civil appeal 96 of 90.
Title suit of 86.
Yes, ladyship. Civil appeal number 26 of 1990.
Yes. Yes, tell us. The suit was filed.
So, decree for declaring dependent, the original defendant who died during the pendency, ladyship, is not the son or heir of the common ancestor as they are claiming to be Balram Mahbub. Third, for decree of permanent injunction restraining him from the possession of the, for taking the possession of the suit land. Ladyship, the fact of the case is that the defendant and the plaintiffs, they were in the litigating terms. Earlier, a suit was filed by the original defendant Mantu Mahto as title suit number 3 of 1981. That was filed for half of the portion of the scheduled property, which is the scheduled property of this suit as well. The suit was decreed on 21/7/1982, the previous suit. Suit was decided ex parte as no WS was filed by the husband of the current plaintiff, husband of the plaintiff. Application under Order 9 Rule 13 for setting aside the ex parte decree was filed by the husband of the current plaintiff, but that was also rejected being time barred. Then again an objection when the plaintiff came to know about the rejection and the decree that was passed on the previous suit. She also filed objection to that, but it was rejected again being time barred.
That
So-
became final.
So that became final. Now the suit which has been decided against me in the suit as well as in the appeal, title suit and as well as the appeal, on the ground that it is barred by the res judicata. Because the property is the same, scheduled property is the same,
Parties are the same.
litigating parties are the same. Now the question here is, ladyship, the question that has to be decided, the substantial question of law would be whether when the issues were different in that suit and this suit, that was for partition suit for half share of the landed property, and here it is a declaratory suit. The entire suit that has been discussed by both the court belows, they have taken into the note that a suit was filed. It was never brought on record by the defendants. We have taken a plea that the declaratory for the declaratory suit that the defendant is not the full brother of the plaintiff, husband of the plaintiff. He had no say over the property, and it should be declared in the name of.
But the status of the party was declared in the partition suit, isn't it?
In the partition suit, WS was not filed, and
Maybe.
it was yes.
But that has become final. The
That
status
was
of the
never-
parties was declared in the partition suit.
That was never brought on record before the court below. Neither the suit, nor the play, neither the decree, nor the play.
That was not
nor
exhibited.
No, it was not exhibited. And relying on those documents, which have never been exhibited before the court below, the decree has been.
Document means it was produced but not exhibited.
No, it was neither produced nor exhibited.
Then how the court
They
has
simply-
relied upon that document?
That is the case.
Only on the point of pleading.
Yes, only on the point of pleading, and one document that was produced by them was the objection filed by the husband of the present plaintiff. That was the objection at that point of time. We have denied that document to be genuine. And the
So the
entire.
plea of res judicata has been decided without bringing on record
Yes.
the details, the documents
Yes.
relating to the previous proceedings.
Yes. And the issue in this case and in that case, that has to be seen to declare that, to come to a finding that it is barred by res judicata. May I read the finding part from the appellate order, ladyship, that covers the entire point of the title suit or whatever ladyship pleases. Order of appeal, the judgment passed by the appellate court is a small one which has taken care of all the points stating below. And this one will be an elaborate, whatever
You see, point number 1
Yes.
is decided against you or against?
Yes, all the points have been decided against you.
Point number 1 is also decided on the basis of the previous suit.
Yes, on the basis. Every point has been decided on the basis of the previous one, which was never in front of both the court.
We need to rise right now. We can continue to move. The matter has remained inconclusive. Pose this case for further hearing.
So
Serial
need a
number.
copy of the judgment if I think ladyship wants to go through it so that Para
Serial number 21 and 22, may kindly list supplementary list tomorrow also.
क्या है 22 क्या है
Pickup नहीं हो रहा है. Second appeal.
टेकअप नहीं है इतना आसानी से हमारे कोर्ट टेकअप नहीं होता बहुत स्लो कोर्ट है
नहीं हो जा रहा है. ऐसा नहीं. Sorry मेरा कहने का गलत सेंस नहीं है. बस
जब आपका केस आएगा ना तब आप बोलेंगे बाकी सब केस भूल के सिर्फ मेरा ही केस सुनिए
नहीं but मेरा यही प्रेयर है अगर है possibility
कौन सा है बताइए
21 and 22 supplementary list if lordship permit. This is my prayer.
क्या मैटर है
मैटर है हम सेकेंड अपील में है रिस्पोंडेंट लास्ट वीक में टेकअप हुआ था अपीलांट अपियर नहीं हुए थे और सेकेंड केस जो है वो सक्सेशन का केस है उसमें हम अपीलांट
अदर साइड है
अदर साइड अपियर नहीं हुए थे नेक्स्ट वीक में लास्ट वीक में लॉर्ड्स
मिसेस मजूमदार को खबर कर दीजिए शी इज अपीयरिंग
हाँ हम इन्फॉर्म कर देंगे
इसी केस के लिए बोले थे क्या रोज लिस्ट करेंगे
हाँ इसी के लिए मैं बोल
ठीक है कल हम कर देते हैं लेकिन अगर कल वो टाइम मांगेंगे तो हम उनको मना नहीं करते
हाँ ठीक है कल मांगेंगे तो एक नेक्स्ट डेट कोई डेट तो फिक्स हो
उनसे कंसेंट लेके
हाँ।
दे देंगे
कंसेंट ले लो
ठीक
Ladyship, this matter will be listed in the first half or in the second half?
it will be listed in the first half in continuity in the morning